Right, let me call page 8. This is case number 822-85949-OC. This is Wesley Robertson versus Kody Gorden. Could I have, once everybody gets up here or on blue jeans, could I start getting appearances?
Gene Backus, appearing on behalf of AD Baseball LLC.
All right, good morning, Mr. Backus.
Good morning, Judge Dale Hayes on behalf of Kody Gorden.
All right, good morning, Mr. Hayes. All right.
Wait, Marjorie Hauf on behalf of the plaintiff.
Good morning, Ms. Hauf.
Under Matthew Friedman, 11571, on behalf of Fraser Inouye, is present in the courtroom.
All right, good morning, and good morning, Mr. Inouye.
Good morning, Your Honor. Loren Young for Michael Stiles.
All right, good morning, Mr. Young. Okay, so you received my minute order. You see that, is it Freeman or Friedman?
Friedman.
Friedman, with a D.
Yes, like
Okay.
Friedman, Judge, but we pronounce it
Or
Friedman.
Freed, all right.
That's correct.
All right, Mr. Friedman, it's your motion. You'll see that I'm inclined to grant it in part and I believe deny it in part, at least with regard to one claim, if I remember the invasion of privacy claim, if I
That's
remember that correctly. So it's your motion, so I will let you make the argument.
My understanding, Judge, was your preference was to allow
Sure.
plaintiff to go first based on
Since
the original minute order?
Since it was granted in part and denied in part, I didn't know if you wanted to try to move me off my position on the portions that I'm denying.
Candidly, I think with respect to your rulings, I think you're spot on. I think the three negligence claims have to go. There's no duty alleged, and I don't think even there's a legally cognizable duty for a third party in the manner that it's framed. So I think you're spot on there. I think with respect to the slander claim, I think that the nebulous nature of a false story, Your Honor aptly points out, we can't answer that without a more definite statement there. I think certainly the consortium claim, they have to plead some facts, as Your Honor indicated. Even if it's just ultimate facts, there still needs to be something more than this caused loss of consortium. That's not proper. So that needs a more definite statement. While we take some issue with the nebulous nature and sort of the way that the allegations, are they photos, are they videos, is it a singular one? We think there should be more definition there, but I understand Your Honor goes from your
You
perspective.
send photos?
Right.
You should know.
I understand that. So
Yeah.
as I said, as you left it in your minute order,
Yeah.
we were perfectly satisfied with.
Okay.
I'm happy to answer anything on rebuttal, but I would leave the floor to plaintiff's
Okay,
counsel.
Ms. Hauf.
And Your Honor, I understand the position that you've taken in the minute order, and I am not sure I necessarily disagree other based upon what we know at this point. With regards to the negligence and gross negligence claims, I understand that there is a concern about what duty he may have had to my clients, and that is obviously something we're going to have to develop through discovery. So if you are inclined to not allow us to do a more definite statement at this time, I would simply request that those be dismissed without prejudice so that we can rebring them if we have discovery for those two issues. However, with regards to the negligent infliction claim, I think that is well pled, specifically with regards to the allegations that he disseminated photographs of her, which he should have realized would cause her emotional distress and harm, if not intentional, at least on a negligent basis. And since those claims will stand specifically with regards to the dissemination once a more definite statement is made, I think the negligent infliction of emotional distress claim would be supported based upon the same facts that the invasion of privacy claim is.
But Ms. Hauf, isn't I'm going back to my minute order for a second. I think my issue with the negligent infliction of emotional distress claim is I don't disagree with you that with regard to what you argued, that would have probably risen to the level of, defeating a 12b-5 or more definite statement motion. But that's not actually what was alleged in the complaint, unless I missed something in the complaint. I think in the complaint, you tied the you tied the negligent infliction claim to the same duty that you tied the other two negligence claims to.
Right, exactly. And I think that is a more definite statement is justified with regards to that claim as well.
I don't think it's a more definite statement. I think you just have to move to amend the complaint because it's a more definite statement still has to be tied back to the allegations that were made.
Right, to the appropriate claim that's going to stand versus the negligence claim that's standing. We can certainly do that in the amended complaint within a more definite statement if we're allowed to do that.
Okay. Anything else on the other matters?
No, Your Honor.
Okay, so Mr. Friedman?
I would come back to with respect to the notion of negligence, and we briefed this at length, so I won't regurgitate it, but I think there's a very difficult time trying to hook a third-party duty And so I think you're right as to the negligence and gross negligence. I think they run into a similar issue with respect to the way, as pled, as you've indicated, the negligent infliction claim is, because it is tied to this sort of nebulous code of conduct duty that is not really recognized under Nevada law. I do think they need to seek leave to amend. I don't think they can simply grant a more definite statement there. So I don't have much to add, Judge. I think your minute order pretty well landed the plane for us.
Okay, so now we're in a weird posture because I'm granting the motion with regard to more definite statements. So you have to refile and provide a more definite statement with regard to the
Consortium and slander, right?
consortium and slander claims. But you're going to seek leave to amend the negligent infliction of emotional distress claim. So I suppose we'll do this in two. I think the cleanest way to do it is in two steps, unless I have a lot of counsel on this case. So if other counsel have better suggestions for me, please tell me.
And Your Honor, if I would suggest as far as the order is concerned, allowing us to provide a more definite statement with regards to the invasion of privacy, the slander, and the loss of consortium claim, and amend with regards to, I mean, it's really a matter of semantics, right? Whether it's a more definite statement or an amendment. The amendment, I think you're right, is the proper legal procedure, and give us leave to amend the allegations of the negligent infliction of emotional distress, and then the negligence and gross negligence will be dismissed without prejudice.
Okay, so first of all, invasion of privacy claim, I said that was
That's the
sufficient. So that's the one thing that's just, nothing needs to happen to that claim. It just needs to be answered eventually.
It sounds to me, Judge, I apologize, like
It's
it's
okay.
more definite statement with respect to slander and with respect to the consortium. It sounds like granted 12B5 on the negligence and gross negligence and negligent infliction, and then essentially the more definite statement with respect to those two, and the one invasion of privacy stands. That's what.
So this is how it is. It's a without prejudice dismissal on all the negligence claims. It's the negligence, gross negligence, and negligent infliction of emotional distress. However, it's a without prejudice dismissal, Ms. Hauf, so you can move to seek leave to amend, including immediately if you want to seek leave to amend the negligent infliction of emotional distress claim. Evasion of privacy claim stands. The slander and loss of consortium claims, you need to provide a more definite statement in a pleading.
All right, Judge.
So, Your Honor, it would, as far as the order is concerned, can we word it as I made an oral motion to amend to amend the negligent infliction claim, so we can just have one amended complaint and get this case moving?
I need to see it before I can grant it. So I need to see the proposed amendment to the negligent infliction of emotional distress claim before I can grant that.
Okay, understood. Yes.
All right, and then Mr. Friedman needs to have an opportunity to oppose.
Okay. So
You
you need
also
to file a
had some
second motion
answering
on that.
defendants as well, Your Honor. You also had some answering defendants as well, unless, I mean, I would assume she needs to. It's just amending as to my client, because some of those same causes of action exist with respect to Mr. Young's client as well.
But they didn't. They
I agree.
didn't ask to dismiss it.
I agree. I completely agree, Your Honor. But I'm just saying it could create a interesting situation moving forward when we have sort of the same causes of action alleged with different elements for different co-defendants.
Sure.
I would leave that to Your Honor.
I think she's going to have to expound upon. It's basically an addition of a negligent infliction of emotional distress claim that's more specific to your client.
Understood. If
Right.
that's your order, I understand, Judge. That's fine.
Okay. All right.
Yes, understood.
Ms. Freeman, will you prepare the implementing order, run it by Ms. Health and everybody else?
Happy
It's
to
due
do
in
so.
2 weeks. In chamber says check for the 19th.
Wonderful. Thank
Okay.
you,
All
Judge.
right. Thank you.
Thank you.